When you're looking to buy a house, there's nothing more important than a solid relationship between your lawyer and you. Your attorney is there to make sure that a transaction runs smoothly and to close according to your terms. Real estate attorneys tend to be deal makers who want to see everyone happy. But there are some client choices that can really grind our gears. This video explores 5 common buyer behaviors that are sure to get on your attorney's nerves. Come on in and have a seat. I'm Ben Weaver, Illinois attorney and founder of 23 Legal. I provide personal, practical, and professional legal service by guiding clients through the process of buying and selling a house throughout Chicago and its suburbs. As a real estate lawyer, we're always happy to help our clients through thick and thin with a wide grin on our faces. However, there are always buyer behaviors that will get you on the naughty list. Here are 5 things that can do just that. Number 5, a sudden lack of ability to attend the closing. You know, contracts usually have well over a month of time from the buyers and sellers signing the contract to the closing. In fact, a month can be considered a fairly quick turnaround. With a solid 4 weeks or more of notice, it's expected that the buyer can take the time out of their day to attend that closing. It's suggested that you just go ahead and take the full day off of work if possible. If a buyer is purchasing the house with a loan, they're required to attend the closing in person to sign the mortgage, note, and other important loan documents. But Lord knows, there's so much that goes on the closing day that you're going to want extra time to tie up any loose ends. Start moving in, and what the heck, just relax at some point. Emergencies happen, and for that, we can understand something coming up. But keep in mind, attorneys, realtors, title companies, lenders have built their schedule around your closing pretty much as soon as we have the completed contract in. So, a last-minute change will inconvenience everybody. Number 4, changing lenders mid-transaction. First and foremost, if the lender has made it clear that they cannot complete the loan, then we completely understand a necessitated change. You kind of need to make sure your money is there at closing, right? But that is the one exception to the rule. Changing lenders, either because of different rates or a bad relationship, could do far more harm than good. A lender usually requires 4 to 6 weeks to process a loan, and not only can this delay everything by a significant amount, it can also be considered a breach of contract. The loan application is required to be submitted 2 weeks after the signing of the contract. Changing lenders after that point can make the entire contract null and void. It's avoidable and it can be infuriating. Number 3, preparing closing funds. We mentioned the breach of contract in number 4, but there's more that goes into the entire closing process with the loan than simply securing it. It also means doing your due diligence in the days coming up to the closing. Now, a couple days before the agreed upon closing date, the lender will provide the buyer's cash to close amount. Please, as soon as you can, wire those funds or go to the bank for the cashier's check. Now here's the difference. If the amount needed to close is less than $50,000, a cashier's check will work. If the amount is $50,000 or more, the funds must be wired to the title company. It's an easy thing to do and will help ensure that the closing goes off swift and smooth. Delaying the deposit until closing day can cause a long delay on the back end. That will not only prevent us from moving on with the closing to whatever we have next, which could be another closing with another client, but it will also delay you receiving the keys to your house. Dragging your feet on the loan hurts everyone, including yourself. Number 2, asking for way too much during the inspection. Look, the reality is that no house is perfect. Even when you buy a brand new home, the buyer and builder create a punch list of items to address after closing. Obviously, things like mold, radon, and current health or safety issues with a house will need to be addressed, and that's fine. Sellers are probably expecting something of the sort. Maybe the inspection unveils an issue with the windows or the back deck that you also like addressed. Again, understandable, but you also have to respect the seller and be sure that you are not insulting them with either repairs to address or compensation for them, making demands that the seller repair some chip paint, or requesting $10,000 because of a window with a draft. Not gonna cut it. While part of my job is to guide you to the best recommendations for repairs and compensation, understand my recommendations come with 10 years of knowledge and experience in this exact field. To blatantly ignore your attorney's advice will make us wonder why we're here in the first place. Number 1, more inspection requests after attorney review is closed. So we have a 5 business day review window for a reason. Once both parties fully agree on the terms, the expectation is to move on and prepare for the closing. Trying to bring up issues that we have already come to an agreement on, or trying to bring up new issues not previously considered problematic, will only lead to frustration for all parties. Frustration for the seller, who thought they agreed they were past this stage. Frustration for both attorneys, who will now have to ask and answer for issues they have already agreed upon. And honestly, frustration for you, when you're inevitably told that those issues cannot be addressed or resolved at this point. Pushing to have it brought up once again will likely insult the seller, causing them to be less than cooperative with the rest of the process. The seller's attorney will no longer want to hear from us on the buyer's side, which also puts our relationship and reputations with other attorneys at risk. It's a lose-lose for everyone, so please respect the attorney review window. So that's my attempt to let you know how we really feel. Sure, most attorneys will smile and say no problem if one of the issues comes up. We're deal makers and we want you to be happy. But the issue will complicate the transaction, and boy oh boy do we know it. The most important thing I think you can do is stay on top of the deadlines, and if we offer advice, please consider why we're offering that advice in the first place. If you're paying an expert in a field to represent you, it makes sense to take the opinions into consideration. Like this video if you found it helpful, and be sure to subscribe to 23 Legal for more real estate law content. I'm Ben Weaver, open to taking new contracts and clients, and I'll see you in the next video.